Okay, welcome everyone. It's August 11th. We're a little early this month. Normally we do these webinars the third week. We're going to do it the second week this month because of a scheduling conflict. So thanks to everybody for their your being flexible on this. My name is Kevin Mosher. I'm a certified specialist in labor and employment law, partner up in the Temsico St. Paul office, and routinely bring you this HR best practices webinar series. So this month we are, in last month, for those of you who participated in the mid-year legislative update webinar, this month we're going to cover some of the overtime issues that we talked about a little bit more in depth, since we covered a bunch of topics last month. So this month we are going to focus. We're going to go all in on the overtime, the new overtime regulations, and what they are and what they aren't, and try to just understand everything that we basically need to understand from these new regulations that are coming out December 1st. So for those of you who have indicated that you need HRCI or SHRM, I think it's PHR, I always forget that, but anyway, SHRM credits, if you've indicated that, you'll get a certificate eventually in the weeks to follow through email from us. And then if you do have any questions, some of you have already been typing in questions, which is great. So there's a little question box. You're welcome to ask questions. I cannot guarantee I'm going to get to the questions, but I think we'll have some time today for some pauses to see if any of the questions are still outstanding. So thank you for any questions that you do have. I also may try to incorporate the little highlighter pen. I've been monkeying around with GoToWebinar after all these years and realize that there's a highlighter pen, so I might try to use that today. So that's my personal goal, is to effectively use that highlighter pen. Okay, so all right. So what are we going to cover today? We're going to go back a little bit in time, and we're going to look at the changes that have been occurring with these overtime regulations since just before 2004, and then the major overhaul that occurred in 2004. So if you're like me and you were back doing this sort of thing back in 2004, I mean, that was a big overhaul. That's not what's happening in 2016. The changes that we're going to talk about today are minor and nuanced, very minor compared to what occurred in 2004. So for those of you like me who went through the scars of learning and seeing the repercussions from 2004, from regulatory changes in 2004, don't fear. 2016 is not going to be nearly as bad, and there's not nearly as much to learn, for better or worse. So we'll talk about that, and then we'll primarily focus on the new overtime regulations. Okay. Okay, so looking back, yeah, my kids call me old, like dinosaurs and stuff, which is kind of ridiculous. I'm really not all that that old, I don't think so. Anyway, this picture, my 9 and 12-year-old selected for me when talking about something as far back as pre-2004. So anyway, so what did we have? Pre-2004, what did we have? Well, we had the salary basis test that we still have today. That's good. But do you remember the long test and the short test back in the good old days when you could pay somebody about $4.25 an hour and call them exempt and have them work 80 hours a week? Those were the good old days, right? And so that was the long test and the short test. And just very briefly, because thankfully there is no longer a long and a short test. Pre-2004, we had this long test where we looked at the duties, and the duties for the long test were that you had to you had, I think I actually got these backward. I think the long test was 155 and the short test was 255. So anyway, but the long test was that you had to meet additional duties for the EAP, for the executive, the administrative, and the professional exemptions. So you know, for like the executive exemption, you had to manage or supervise, as well as, you know, like 2 or more people, and so you just had to meet like all these criteria. And then for the short test, it wasn't as onerous as long as you paid them more money, and that's why I think I got these inverse. So so we've got the long and the short test. Fortunately, in 2004, that all went away, but we still had, you know, this whole thing. We had salary levels, so we had to pay a certain salary, and that salary had to be guaranteed minimum of at least either 155 per week or 255 per week, and they had to meet the same, you know, type of duties that we still talk about today. So then in 2004, we had a major overhaul of the Department of Labor regulations, and the major excuse me, and the major overhaul was to redefine a little bit of what the salary basis test was, and then you know, big news, moved the salary level test, because there are 3 tests, right? There's the salary basis test, which means if you want somebody to be exempt from overtime pay, you've got to pay them at least on a salary basis if they're an EAP, an executive, administrative, or professional level employee. There are certain exempt employees, exempt from overtime payments, that you don't have to pay on a salary basis, like teachers and lawyers, doctors, but for everybody else within that EAP category, you need to pay them on a salary basis. So in that salary basis has to be a guaranteed minimum amount of salary that you pay the person per week, not per month, is per week. And that level, so the salary level test is the second one, that level changed from 155 or 255 pre-2004, changed to 455. And we haven't had any changes since. So, you know, when we talk about these new regulations in a little bit, we're talking about changes to the salary level. And we're talking about salary level changes that haven't occurred in about 12 years, which is why I think the Department of Labor kind of overstretched a little bit as to, you know, who they think is an appropriate exempt white-collar employee. In 2004, the Department of Labor created this highly compensated employee, HCE level, and that highly compensated employee level moved to $100,000 per year. So it was you know, one of those situations where they said, well, I mean, if you're making $100,000 or more per year, I guess we're not going to really care as long as it kind of seems like you're doing some of the white collar EAP duties. So just an easier test. It's just easier to qualify if you're making over $100,000 a year. I guess it's just a way of the government saying they really don't. If you're making that type of money, they don't care nearly as much. So this happened in 2004, and that's the world that we have been in ever since, until we're going to move on to December 1. Okay, so since 2004, what has happened? Well, there are several things have happened. One, there's been a ton more litigation. We'll talk about that in a second. But 2, the Department of Labor has really gone on a rampage with their enforcement. And so you can see by just like this chart alone, take a look at, this is through 2015, so it doesn't include fiscal year 2016, but it's through from 2009 through 2016, we're looking at $1.6 billion in back wages recovered by the Department of Labor, Wage and Hour Division, WHD, Wage and Hour Division. And so the 1.6 billion, and that doesn't include lawsuits, and most of the money's been recovered through lawsuits. This is just where the Department of Labor has been involved, and so they talk about 1.7 million workers. And so these are, statistics that the department throws out there as something that's really fantastic, and they're doing a great job enforcing, but really it's kind of unfortunate, because that really means that their department's going after a lot of businesses, primarily small businesses, that didn't fully understand the regulations in 2004 and the changes to the duties and all of that. And then at the same time, we have, an explosion of independent contractor, of contingent workforce employees that are, and those are now being cracked down on significantly in the last few years, and I think that will be ongoing, where employers have misclassified independent contractors. But a lot of the reason that employers misclassified independent contractors is because these, well, first of all, independent contractor law is confusing. And then second of all, because they made it so hard for these businesses to survive with these new regulations on the duties, and so it's just easier to explore the contingent workforce, call people independent contractors, normally incorrectly, and then avoid having to worry about all these overtime laws, as well as other things like FICA and that sort of thing, which are all problematic. But it all leads to a big mess, which is kind of the what's going on right now and has been going on for the last few years, but I don't think it's going to get any better in the foreseeable future. Other look at this just in 2015 alone. You can take a look at this chart to see how much in back wages was collected for more than 240,000 workers. So particularly since 2009, during the Obama administration, it has been incredibly aggressive in recovering money and enforcement for wage hour claims, primarily over overtime. You can see the number of claims filed here. It's been increasing, and it just continues to increase, and you can see the jump. I don't know why there was a spike in 2006 and 2007, but for whatever reason, I mean, there's an increase here, and a lot of this is because of the complexity with these new regulations since 2004. So what did the lawsuits that we've been dealing with since 2004 primarily? Uncompensated overtime, again, the biggest one is not fully understanding the administrative exemption. A lot of employers overuse the administrative exemption. It's hard to understand it. It's easier to understand the executive exemption, for example. The executive exemption, you just have to supervise or manage 2 or more full-time employees within an individual unit or division or department within the company, and perform hiring, firing, those sorts of duties. And so that's pretty easy to understand. The administrative exemption is a little bit harder. The professional exemption is pretty limited to just people who are actual professionals within a learned or artistic profession. So those are a little bit easier. The E and the P are a little bit easier. The A is not so much. And then there's a lot of miscalculation of overtime. A lot of employers don't understand, for example, that when you give bonuses that are non-discretionary, like performance-related bonuses, that sort of thing, those bonuses need to be calculated into the overtime rate. And so if you give an annual or a quarterly bonus, well, it needs to be aggregated across that entire period of time that bonus covers. And so if somebody is a non-exempt employee and they have worked overtime 1 week, then that bonus needs to be recalculated into that, and the person might be entitled to a little bit more pay, even weeks or months later, than they initially received. So these are the other things that the lawsuit does: misclassification, compensated for travel time or off the clock work time. Again, this law has been complex. It's not going to get any less complex. So what I'm talking about now, since 2004, I do not see any of this changing. That we'll go back. That chart that you can see right here, the rapidly increasing cases, and expect it to keep going. It is not, as well as this chart regarding back wages. The changes in 2016, we are not going to see any relief from the changes in 2016. If anything, it's going to get worse because employers don't fully appreciate how, how the salary level necessarily works. So unfortunately, it is going to continue to be complex. It's going to continue to be vague for a lot of employers that aren't sophisticated or don't have HR professionals or payroll professionals watching out for their best interests. And this is an older law. There is a shifting interpretation, though, that tends to shift with the executive branch a little bit, and the amount of oversight tends to shift depending on who's in the executive branch at the time. And but the big thing is that plaintiffs' attorneys have really gotten wind of how easy it is to just get to find unsuspecting employers and to have a pretty easy lawsuit against them, and then to rack up enormous fees. And so, I mean, I've seen lawsuits where the attorney collects many multiples more money in guaranteed legal fees that the company has to pay versus what they collected for their client. It's not technically supposed to work that way, but it routinely does, where the attorneys are collecting much more money than their employees, than their clients. And so we've seen this is low-hanging fruit. A lot of companies misuse the classification of the exempt classification, and don't pay a lot of employees who should be paid overtime. And there's a lot of misclassification of independent contractors as independent contractors when they should be employees. And so it's kind of low-hanging fruit for these attorneys to go after companies, and then they get guaranteed fees. So, from their perspective, sign them up. Okay, let's see. There are some questions. So a couple people have asked for clarification on the administrative exemption. I appreciate that. So with the administrative exemption, without getting completely into all the elements, what I would say is that the administrative exemption is the hardest one to understand. A lot of employers misuse that exemption by giving it to people who are actually performing the work of the company. And so what do I mean by that? The administrative exemption is supposed to be for administrative people who are supporting the operations of the business. So HR people, accounting people, professionals, accounting professionals, HR professionals, other operational type of maybe your safety compliance officers, those sorts of people. They're helping perform operations. They're helping legal professionals even. They're helping with oversight of and regulatory compliance of the business. They're not actually performing the business, right? So HR professionals don't go and sell widgets. They're not, they shouldn't be anyway. So they're supposed to support the business. A lot of companies, in my experience, and personally, and in just being around this industry for a long time, a lot of companies will assign the administrative exemption to people who actually do the work, like they actually sell the widgets. So they are actually out there selling. They're out there producing for the company. Those people are not supposed to get administrative exemptions. It's supposed to be your HR people, your marketing people, for example. It's not your administrative assistants. Administrative assistants, executive secretaries, that sort of thing. A lot of companies want to put executive secretaries, but while they're administrative, the second part that a lot of companies mess up is that the administrative professional has to have independent discretion in matters of significance. And it's very few executive secretaries who have independent discretion in matters of significance. Not to belittle the position or anything, but it's got to be a matter of significance, and what is significant to one company is not going to be is not going to be significant to another. So something significant to Google is not going to be significant to a gas station mom and pop shop down the street. That's just how it is. And so a lot of companies will overuse this, and they'll assign it to all people, who work a lot and might have some responsibility, but do they really have independent discretion? I mean, can they sign those contracts? Can they sign those leases for space? Can they commit marketing dollars to a project? That's the type of discretion and independent judgment that administrative professionals need to make, and so often companies don't really take that into consideration when they're classifying their administrative professionals as exempt. The other thing that somebody asked, and I've done other webinars on this whole bonus repayment aggregation. So I can't really get into it, but I have other webinars and that have been done on this topic, so I can't get into that. Okay, so let's move on, and we'll see if we have time at the end of this for some of the other questions that were asked, and I appreciate everybody's question. So what's going to happen on December 1? So I talked about the three things before, right? We've got the salary basis test, which means you have to be paid a guaranteed minimum level every week. And then the salary level test, which is what defines what that minimum level is. And then we've got the duties test. Now, the only thing that's happening December 1 is the level test, is the salary level test is changing. We were concerned about the duties test changing, and they punted on it. I think it's going to happen in the future, but they didn't do it now. So for whatever reason, they punted on the duties test. So the overall changes that we had speculated, and the legal profession, I guess, that we had speculated would be coming didn't come to fruition. So and the salary basis test is not changing at all either, except for one nuance, and we'll talk about that with bonuses. But the salary basis test isn't going to change. So you're still going to have to pay somebody a guaranteed salary level. If you're an executive, an administrative, or a professional level person, that person needs to be paid a guaranteed minimum level of now, just starting December 1, $9.13 per week if you want overtime. There's no prorating it for part-time employees. It doesn't even matter. Why? It doesn't even matter anyway. If they're part-time, they're never going to work over 40 hours a week, so who cares? But if you want to classify the person as exempt from overtime compensation, starting December 1, you're going to have to pay them at least $913 per week if they're within that executive, administrative, or professional category. For your highly compensated employees, they've bumped it from $100,000 to $134,004. That extra $4 is what really kind of makes or breaks the highly compensated employees. So just kind of watch out for that one. But that's your highly compensated level, $134,004 per year. So it's not per week like we look at with the salary level test, but it is per year. Let's see, things I didn't cover in this. So we'll look at bonuses in a second. A couple other things that one other thing that they threw in is they have scaled this, they are indexing this. So they have now tied this $913, the salary level test, has now been tied to an automatic indexing. So every 3 years, we are starting in 2020, January 1, 2020, that'll be the first year, and then every 3 years thereafter, we're going to see automatic indexed increases of this $913, which is great, right? Think they want to get away from going from $155 to $455 and then jumping, from $455 to $913. So again, here are the exempt requirements. We've got the salary basis test. These are the definitions of them. We've got the salary level test, and we've got the duties test. And like I said, nothing's changing with the duties test. You are still going to have to worry about the administrative exemption being difficult to understand. You are still going, if you want somebody to be an executive exempt, they still have to manage or supervise 2 or more full-time employees. you know, if you want them to be professional, they're going to have a degree in a learned profession. You know, those of us who are wonderful history majors are not going to necessarily be professionals just because we work in a white-collar job. We would have to have a job that requires a history degree. And that's why the professional exemption is sometimes difficult to understand as well. Just because they are performing, you know, duties that, you know, require brains, that does not mean, and for somebody in like a white collar type of job, it does not mean that the person is necessarily a professional. Okay, proposed changes. So we're going to go from 23,600 per year to which is 455 per week, and we're going to jump up December 1. We're going to jump up to 47,476 per year, which is the equivalent of 913 per week. So this is what we're moving to. There's no getting around it. A little bit of a window of opportunity. We'll talk about that in a little bit here. But this is the new reality, and this is really the only change. I mean, there's a lot of people, you know, not necessarily HR professionals, but a lot of people, if you just talk in the media or you look online, I don't know what it is about changes from the government, but people just, I don't know if it's just politics or what, but it's like people think the whole world is completely going crazy and with this change, and it's really pretty simple. You know, you might have heard a lot of people making a big deal about it, and that's fine. And it is a big deal. It's a lot of money if you want the person to go to be exempt. I mean, you're gonna have to jump their pay up to 913 per week if they're not making that right now. But the complexity of this regulation, it's just not really there. This is really just more of a monetary change, which is what the government wanted to do. I mean, they wanted to collect more money for workers. I mean, this, and just stepping back a little bit, this entire regulatory change is entirely because of the administration's desire to increase wages primarily for single moms. And we'll look at the statistics on why I say that in a little bit here, but it's primarily to shift money from companies to workers, and they've gotten nowhere with the minimum wage at the federal level. State level, local level, absolutely a lot of movement on minimum wages there, but at the federal level, there's no real movement or political willpower to get anything done on the minimum wage, and so this was a back-ended way through the regulatory process to shift a bunch of money to workers, primarily some lower level like assistant manager types and that sort of thing. Yes, okay. So again, we're going to look at some automatic increases, and how did they, you know, just stepping back as well, how did they come up with this 913? I mean, it wasn't just pulled out of the air. There was no, you know, roundtable meeting and, you know, who votes in favor of 913. You know, it wasn't one of those. Although it kind of seems like they did not arbitrarily just choose these percentiles, but they looked at the 40th percentile for wages for executives, administrative, and professional employees. So they looked at the Bureau of Labor Statistics, and they went with the lowest wage region in the United States, which is currently the southern region of the United States, and they just said, you know, in our estimation, we think 40 percentile. So if you want to be exempt, you really should be paid at least within the 40th percentile of what the BLS says for the lowest wage region in the United States, which is the southern. So the 40th percentile in the Midwest, in the West Coast, and in the East is not 47,000 and some change. It is, you know, it's not 913 per week. It's a little bit higher than that. But they went with the lowest. So this 40th percentile is how they came up with the 913. And then for the HCEs, they didn't look at the South. they just looked at the entire country, the BLS statistics for the entire country, and they said, well, we're just going to go with the 90th percentile. If you want to be a highly compensated employee, you should at least make in the top 10%, right? So that top 10% nationally is $134,004. So there you go. If there is one person in the United States that makes exactly $134,004, they are exactly in the 10th percentile of wage earners in the United States. So that's how they came to this 913 and the $134,004. They looked at statistics. And the initial regulations, when the proposed regulations when they came out, that's how they were going to measure it as well. So they really didn't deviate much from that. But then the automatic increases, initially they wanted to do it annually, so every year we were going to have to deal with a new increase. And so it was going to be either like a reset, like are we going to look at the 40th percentile, or are we going to look at the consumer pricing index and see what the inflation rate is? If the inflation rate's like 2%, then the 913 every year is going to go up by 2%. They looked at there were 3 different ways to look at this, and they settled on hey, we're just going to keep this. We're going to apply the 40th percentile in the lowest wage region, which let's just assume it's going to be the South again. And so we're just going to apply that 40th percentile, and so that first increase will be January 1, 2012. And if all things stay as projected, which they won't, but just projecting right now, January 1, 2020, based on historical data of wage increases in the South, that 40th percentile is estimated to put the salary level test for the entire United States at $984 per week. It gives you kind of something to plan for, I guess. We are not going to know, however, until at least 150 days before the increase. So the Department of Labor will issue a register notice, a notice in the Federal Register stating what the increase is going to be. So, check back with me in January, probably 4 years from today, basically is what they're looking at doing. So they're going to announce it, and so estimated it's going to be $984. We'll see. It's probably going to be close, but it's not likely to be exactly $984. That's the estimate. Highly compensated employee, $147,524. So this is what they estimate wages will be looking at. So it's not over, and unless this whole scheme gets completely overturned in like a Trump administration. I was going to say dictatorship. It really probably wouldn't be appropriate. So, but administration, unless he completely undoes it, which could happen, absolutely could happen. This is what we're looking at. I mean, we're looking at an every 3-year automatic increase based on the southern region applying these 40th and 90th percentiles. Interestingly, a couple days ago, I saw this, the Department of Labor, they put out a lot of crappy spin, personal opinion, and this is one of them. I think it's worth reading. It just kind of shows you where the government is right now with this. I mean, it's one thing to say, hey, look, we need, we're getting out of line here. I mean, exempt employees shouldn't be paid overtime. It should be paid overtime, and exempt employees who are working like 80 hours a week, low level, making $24,000 a year, they should get some overtime. Okay, so I can kind of get that argument, and we need to update it every once in a while. But here's what the Department of Labor wrote. This is 2 businesses, so telling businesses how great this automatic increase is. And so I'll just skip forward, and if you read the last paragraph, automatic updating to maintain the labor standard set out in the rule is good for employers and it's protected workers. So it's good for you, businesses. It is the very definition of efficient, effective government that we all champion and strive for. And Their basic point was, by putting this on an automatic system, we don't have to go through this crazy regulatory process with all the politics and all that. It's just going to be automatic. And so many states have adopted this same indexing. And so many states, I mean, Minnesota has, a lot of states have. They've adopted this indexing. And so the Department of Labor is doing it as well. I mean, Social Security does it with Social Security benefits too. But this is the first time I can think of, although I mean, it's probably out there. I just haven't heard it. But I'm not familiar with any other regulation along these lines that the government has just said, you know, anticipate increases, just automatic increases every few years. We're just going to automatically reset this. So I guess it's efficient government in action, and I mean in action. New bonus. Okay, this is the only kind of curveball complexity to this new salary level, and it's actually a bone that they threw to the business community. So the new bonus rule is this, and I think this is good. So this might really work for a bunch of you out there, given, you know, based on what you've got going on with your workforce and how you do compensation. Okay, so the new rule is that you could, that $913, you could pay 10% of that. So you can't get away from the 913. I mean, you got to pay the 913, but you could, but 10% of that could come in delayed non-discretionary bonuses or incentive pay or commissions. So for those of you that are paying commissions on, let's just say, a monthly basis, you can count those commissions toward the weekly figure, because you have to pay $913 per week. Now you can still pay every other week. I mean, that's fine. You can still do a payroll every 2 weeks. But if the commissions are coming weeks after that because of calculation and how they, and you know how they're done, if the commissions come after that, then the 913 could be, then 10% of that 913 could come from those delayed commissions, and the furthest out that you could use this 10% is quarterly. So it can't be like it can't be an annual non-discretionary bonus or an annual incentive pay or an annual commission, but you could do at the most at the furthest quarterly commissions, and you could count that commission or that bonus or that incentive pay, you could count that toward up to 10% of the salary. So for those of you who are compensating employees like this with non-discretionary bonuses, incentive pay, commissions, that sort of thing, and you want to take advantage for these EAPs, and you want to take advantage of this rule, you could pay 913 minus 10%, so minus $91.30. So you could pay that much less from the 913, and then as long as you're making up that $91.30, as long as you're making that up in the bonus or commission or incentive pay. And again, the makeup cannot be more than a quarter out, so no more than 12 weeks out. That's it. So this is kind of a bone that they did throw to business, and it's not really being talked about a lot from what I can see. I think it's just not as politically sensitive, I don't think, as raising the level so much, especially in an election season, which is just, I mean, the timing's crazy on this, but that's just how things go. And so this is actually a really, really good thing for the business community, and it, you know, maybe it'll alleviate a little bit of the pressure from having to move a bunch of your employees up to 913 per week, particularly when they're getting this other sort of incentive pay and non-discretionary bonuses and commissions. I will say you may need to review those agreements that you have with employees. You may need to review them and you know, so if they are being paid out more than quarterly, that you then review them so that you're paying them out on a quarterly or more frequent basis. So if you're doing annual, you know, you might want to reconsider that if you're trying to take advantage of this 10% rule. what wouldn't count toward the bonuses. And so this is fair. It's not everything. So we're not going to count boarding and lodging. We're not going to count discretionary bonuses. And discretionary bonuses, I mean, there's a real nuance to those, right? Because discretionary bonuses for non-exempt employees, count toward or don't count toward the calculation of the overtime rate, and then payments toward medical. So your ERISA benefit type of payments and employment and retirement plan contributions like a 401k or that sort of thing, they're not going to count toward this 10% fringe benefit stipends. So that's not going to count. It's just going to be commissions, incentive pay, and non-discretionary bonuses. So things that are pursuant to an agreement of sorts between you and your employees. And we'll see. We'll see what type of enforcement we get on this. But I think this is a great potential for employers. I see some questions. Okay. We're making good time here. Hang on, let me see. We've got, okay, thank you for all the questions. I'm gonna have a hard time reading through all these and answering them. Let me see. Would a manager who supervises only one employee and earning $101,000 annually be exempt from the classification as an administrative exempt? So as a highly compensated employee, and I'd have to double check on that one. That one I've not seen come up. Generally, I think the answer is no. I can't honestly give an answer on that. I think it's the other duties regarding that they would be performing that they might be that they might have to back off on. So I'm going to have to follow up on that one, and then so I can see from all the questions that this is going to be the webinar that I have a lot of follow-up, and so everybody will get a letter from me emailed to them. Everybody who's registered for this webinar will get an email from me going through all of these questions with appropriate responses. I want to make sure everybody gets the right information. Does the 10% bonus rule affect non-exempt employees who are paid less than $913 per week? And the answer to that is no. The 10% bonus rule is it works to get up to that $913 per week. The bonus rule for non-exempt employees, whether they're paid, $1,000 a week or $200 per week, the rule with that is that if the bonus is discretionary, or if it's like a retirement plan type of thing, and there are some exceptions. There's a lot of nuance to this. But if the bonus, let's just talk about discretionary bonuses. If the bonus is discretionary and the employee has not come to expect it, and they haven't done anything where they knew, like they didn't do anything where they knew, like, hey, if I do this, I'm definitely going to get a bonus from the company. There's no agreement like that. It's wholly discretionary. Then that bonus is not going to count toward the employee's wages. And so when it doesn't count toward the employee's wages, then we don't have to calculate it in for overtime. But where the bonus for a non-exempt employee is like a commission or incentive pay, or it's a non-discretionary bonus, so the employee knew, like, hey, if I sell enough widgets this month, I'm going to get a $100 bonus. If that's the situation and they're a non-exempt employee, then that bonus, whatever it is going to recalculate back into their wages, and it's going to recalculate depending on the period of time that bonus covered. So if it's a monthly bonus, it's going to be divided by 4, and you're going to have to recalculate that $100. It's going to be $25 per week. And if the person has worked overtime, because of the 1.5 multiplier on overtime worked over 40 hours per week, that 1.5, it's that 0.5 there, that's going to inflate a little bit and mean that that person, that $25 is going to be impact that multiplier, and the company is going to have to pay a little bit of additional overtime, very little, but a little bit on top of what they've already paid. because of the recalculation. In this, and again, I've done an entire seminar on that topic alone, and so if there are a lot of questions on that, I could maybe I should redo that seminar in 2017. Okay. Okay, so duties tests, moving on to the duties test, like I mentioned before, there's no changes. The current test is the primary duty test, and so we look at what is the primary duty. Now in California, this was in the California test, which is different, and the California test is kind of like the, back in the day, the long and the short test. And so in the long and the short test, we look at the percentage of time that somebody was spending doing exempt type of work. And so that changed in 2014. Well, California's kind of gone back to that, that long and short test, where California looks at, hey, if you're going to be one of these EAPs, exempt administrative or professional employees, if you're going to be one of these employees, then you need to spend at least 50% of your time on exempt work. Now that's not the current federal approach since 2004, and that was the biggest change in 2004, was saying, hey, we're going to look at the primary duty. And if the primary duty for, let's just say, an office manager is hiring and firing and doing that sort of executive exempt stuff over 2 or more full-time employees, then if that's the primary duty, then even if they're only doing that 10 or 15% of the time, they're still going to be under federal law exempt because they were hired to be an office manager doing hiring and firing and that sort of thing. So even if they're jumping in and they're doing the actual work and they're manning the registers and they're stocking the shelves and they're, you know, making copies, and so they're jumping in and they're doing non-exempt work under the federal test, it doesn't matter. Their primary duty is that they were hired to be an exempt executive and doing hiring and firing and that sort of thing. And that's where if the federal government had adopted the duties test, and I was totally on board with speculating on this, if the federal government had adopted that test, that California test, it would have really impacted retail, convenience stores, hospitality, where you have these working supervisors, these people who, yeah, they're managing, but really most of the time they're jumping in and they're doing everything else that needs to happen. And so fortunately, the good news is the government didn't do that. And so those of you in California are kind of stuck with it. But the rest of us are, and those of us who are looking at the federal law, we got to pass. I think it's still going to come down the future. We'll see. But right now we are still looking at the primary duty test, which we don't look at percentages. They're helpful, but we're not just exclusively looking at percentages. Who is not affected by this? And I'd mentioned some of these before. So who's not? But we need to make it clear. Lawyers, doctors, teachers, right? Because there's no, and why is that? Because there's no salary basis test for lawyers, doctors, and teachers. Outside salespeople, no salary basis test. If you're doing legitimate, not inside salespeople, but if you're doing outside sales, or you're actually you're outside the office, you're going out there to sell, your primary duty is sales outside the office. You don't have to be paid $4.55 per week. You don't have to be paid $9.13 per week in the future. You're exempt. Computer professionals who are doing like programming and that sort of thing, that's still that hourly. It's like $27.63 and I think like 63 cents, something like that. Where certain computer professionals can be paid an hourly rate there. That's statutory, so that's not changing. DOT drivers still, they're not going to be impacted. There are certain retail workers that are certain retail workers that are doing some inside sales in a retail setting. That exemption is still going to be in place. People making more than $9.13, we really don't have to worry all that much about them. It's really, but who is going to be impacted? It's going to be the people who are making less than $9.13 that are working a ton of hours for your company, and you've got to decide, are you going to cut their hours, or are you going to move them up to 913? And the other people, I should say, the other people who are not really affected by this are people working less than 40 hours per week. You know, if somebody's working part-time, who cares? I mean, we only really care if they're working more than 40 hours, and because then we have to worry about overtime. But if they're always working less than 40 hours, then no big deal. It's you know, we don't have to worry about whether they're exempt or non-exempt. You can pay them a salary. That's fine. You can pay them hourly. That's fine too. But we really only care if they're going to work overtime, because we don't want to pay them if we can. And so the only way to not pay them, if they're EAP, the only way not to pay them is if we're meeting that salary basis test and the salary level test of 913 and then the duties test. Impact. 4.2 million people, it's estimated, are going to receive raises or become eligible for overtime. That, you know, it's a lot of people. Anticipated cost, $1.2 billion. I think it's pretty low, but you know, we'll see. So the government estimates $1.2 billion in shifted wages from businesses to these 4.2 million employees. A lot of businesses will look at this 913 per week and say, there is no way I can pay this assistant office manager 913 per week. So then you're kind of given a choice. You can raise the person up to 913 per week and continue to maintain the exemption from overtime, which is legitimate, or you could keep them working a ton of hours. You could lower their salary. You could lower their hourly rate so that the overtime, you know, it's probably not a good morale move, but their overall compensation might not be impacted so much if you lower their hourly rate quite a bit, knowing that they're going to work a ton of overtime. So, you know, there's a lot of accounting that goes into that and a lot of planning. So if you have a bunch of employees there, I suggest you break down the numbers and maybe engage an accounting firm to look into it, because it can get pretty complicated. So, and then there are like 65,000 HCEs. By 2027, they anticipate 5 million people are going to be affected, and 221,000 HCEs. So this is a pretty big percentage of, you know, relatively big percentage of the U.S. workforce that's going to be impacted by these regulations, you know, as they estimate. Who do I think is going to be mostly impacted from my personal perspective? It's going to be retail. It's going to be hospitality. It's going to be small businesses, employers in non-metro areas, places where businesses that rely heavily on their exempt workforce to work a lot of hours, but not for executive level type of pay. And especially in rural areas, you know, $47,000, that's executive level type of pay. Maybe, you know, maybe not in the Twin Cities or Chicago or Dallas, but, you know, in West Texas, you know, Western Minnesota, everywhere else outside Chicago, in Illinois, that is 47,000 and change. That's a pretty significant wage to be paid. The metro areas skew these numbers quite a bit. So retail, hospitality, small businesses, places that, yeah, they're not paying their assistant managers who are working 60 plus hours a week. They're not paying them $47,000+ per year, and they're going to have to make a choice. Do they raise them up to 913 per week, or do they keep them lower and just start paying a ton of overtime, or cap overtime and don't let them work any more overtime, in which case the government would be very happy, because then it'll force businesses to hire more people, and that's one of the other things that they're trying to do here, get businesses to stop overworking employees in certain situations and to hire more people. So percentages that they estimate. They estimate, and again, this is part of the equal pay movement at the federal level. We've seen a lot of that over the years. So equal pay, trying to help out lower wage workers, primarily single moms. They are estimating, I mean, this is right from the Department of Labor. When they're talking about the impact and why this is a good regulation, they're saying that 56% of the beneficiaries are going to be women. 2.5 million children who have a parent with parents are going to be positively affected. So they're anticipating that 2.5 million children, I mean, they're talking about children being impacted. I mean, this is a social issue. In a lot of these wage regulations and discussions on equal pay and executive orders regarding federal contractors and minimum wages on those, that sort of thing. These are social issues. These are healthcare issues. This is to bring people up. That's the argument that's made by the federal government. So 3 and 5 are over the age of 35. So it's going to, I guess 35 is the cutoff for old. So those of us who are over 35 are apparently old enough to be in this 3 to 5. So that's where the federal government's coming from. There is an opportunity still before the election, before December 1, I should say, for this to be derailed. I don't think it's going to happen. I can't imagine. I think Congress people are pretty worried about getting elected at this point. I mean, this election's kind of crazy, and I just can't imagine. And it's a divisive Congress and everything. They can't do, they don't do a whole lot anyway. So it's just too divisive. So is there a chance for the Republicans to try to block this? There is. They could do it. They have 60 it's less now, but they totally have. They have a total of 60 legislative days to veto this regulation. The Obama administration gave them that opportunity, essentially. So they could do it. The likelihood, well, I mean, first of all, if they pass something and it goes to President Obama, he's going to veto it. So they would have to pass it, either... well, and it'd have to be basically Donald Trump would have to come into office. I mean, and so they would pass it within that time period so that somehow, like after the election, so before, what is it, January 20th or 20th, whenever President Trump would take office, so that he could then veto it, and he could undo this. But if Hillary Clinton wins, I mean, this is not going anywhere, and they wouldn't have enough to overturn the veto. I can't imagine. So, do I think it's going to be blocked by December 1? No, it's going to be vetoed if it is by December 1. Could it be blocked and overturned early next year in 2017 after we've all implemented it? So you're going to give a raise to a bunch of people and then you're going to take it away? Yeah, that's possible. And so we will see with the election what happens there. And I suspect this would be one of the things that would be on the chopping block if Donald Trump won. So the proposal that's made by these like blue dog Democrats just a couple weeks ago was this, as you can see in the bottom right. And actually this honestly to me seems very reasonable and makes a lot of sense, but like I said last month, all the more reason why it's not likely to be passed and approved. It does seem like a reasonable phased in approach to raise this, but I don't think that's where we are right now, so I don't see that going anywhere. Okay, let's see. I've got 1 minute. Am I correct in thinking that if all of my non-exempt employees are earning overtime appropriately, earning less than $9.13 per week are not impacted by these regulations? Yes, this does not impact non-exempt employees. We have an exempt duty employee who works 30 hours per week. She will qualify for overtime for working over 40 hours per week. But can she stay on salary? Yes. There is no law that says you need to pay somebody an hourly, like a broken down hourly rate. You can pay any non-exempt employee a salary. The only thing you have to do, so if you want to pay a non-exempt employee a $500 a week salary, and if they work 20 hours, they get 500, and if they work 30 hours, they get 500, that's totally fine by me, and it's totally fine by the, by the federal government too. But if she works more than 40 hours, then you're going to have to figure out what her regular rate of pay is. And so the regular rate of pay will be that $500 that you're paying her in a salary divided by the total number of hours, and then you're going to have to calculate the overtime rate based on that. And again, I'm thinking I'm going to have to do a 2017 webinar because I haven't done it in a couple of years on this exact issue. So plan on it being in probably the spring of 2017. I really appreciate everybody's attention. And we had a really good sizable audience, and I appreciate all the questions, so I will get answers to those when the next couple weeks. The next webinar will be September 15th. Everybody can register for that on our website. Many of you will probably receive an email as well, so I welcome you to register for it. I will not be doing that one, so one of my partners down in our Houston office will be doing it. But then I personally will be back with you in October. So thanks for your attention. If you have any questions, you're welcome to reach out to me or any one of the other labor and employment attorneys at Tomsco. Thanks.